That kind of, I think, laid the groundwork and set the stage for, it didn't get passed the first time around, but it got a lot more publicity and recognition. And the second time around, through the efforts of MAR principally, and some outside counsel, Bob Kuttner in particular, and Philip Payton, it did pass in substantially the form that MAR had proposed. So anyway, the agency law was enacted in 2005. And I'll try to go through this quickly, but this is key. I mean, this really is the answers to the questions that a lot of people have about agency. And, you know, I think there is still a lot of confusion out there, you know. But anyway, so dual agency, this is what needs to happen in order to do dual agency. A real estate agent or broker may act as a dual agent who represents both prospective purchasers and sellers only with the informed written consent of the prospective purchasers and sellers. So that's the first step. You need written consent from the parties to the transaction, the buyer and the seller. And this is dual agency. And the distinction being that dual agency, it's a single agent representing both the buyer and the seller, as opposed to designated agency, which we'll talk about in a minute, where an agent with the firm is representing the seller, and another agent of the firm is representing the buyer. But they can only do it with the informed written consent of the parties, both parties. So that's the first step. Consent to dual agency shall be obtained in the form prescribed by the board and shall be signed and dated. Now that's important too, and you'll see why in a minute. A form prescribed by the board. Sorry.
I have a quick question. When you said dual agency, the same agent representing both parties, it's also for, right, as I was told, as a broker that sells,
Yes.
works with buyers and sellers, anybody in my office that sells.
You would be a dual agent. Is that what you're going with that?
Yeah.
Yeah. I'll get to that too.
Oh, all right.
Okay. So you need informed consent first, and on a form prescribed by the board. Now, the statutes and the regulations lay out what needs to be included in that consent form. The consent form or the contents can be included up front in a listing agreement or a buyer agency agreement. But we all know how many people use buyer agency agreements. So there is a standalone form that can obtain the consent up front, but no later than when the parties enter into an agreement to purchase or make an offer to purchase a property. And the advantage of doing it up front is that you don't wait until it arises and then you say, oh, you know, I forgot to talk to you about this earlier. You know, I'm a dual agent now and I can't do anything for you. Basically, I'm neutralized. So it's much better to obtain the consent up front. We've incorporated that language into listing agreements and buyer agency agreements when they're used. When they're not, we would use the standalone consent form. So that's the first step, to try to get it up front as well. Such written consent may be obtained when an agent's relationship with the seller or buyer is created, but notice of dual agency shall also be given to the prospective purchaser and to the seller after a listed property is first shown to the purchaser. So you can do it up front, you know, at the inception of the relationship, but then, you know, a week, 2, 3 weeks later, or it could be the next day, it could be the same day. When it occurs, there's also a written notice requirement. So that's the second step. And there are standalone forms for that through GREB and through MAR to let the buyers know, basically, oh, remember we talked about dual agency and you consented to it up front. Well, this is just to let you know that we're now in a dual agency situation, and I have some limitations on what I can do under those circumstances. So there is those 2 steps for dual agency.
How would the buyer sign this? So how does the buyer's attorney feel about this?
How does the buyer's attorney feel? And it's not necessary. I mean, it's up to the buyer whether they feel that's necessary or not. But the buyer can make that decision on their own. And you know, if you have discussed it with them up front and they're comfortable with it, then you know it's just a notification requirement. If they're not, and we'll talk a little bit about that, then that raises other issues that you need to deal with if and when that happens. No, I don't consent to a dual agency. I want you to be my agent, and I'm not comfortable you representing somebody else, and now you being neutralized. So we'll get to that a little later on. So again, the two-step process: consent and notice. Designated agency. So this is the other situation I was talking about, where one agent from the firm is representing the seller, and another agent from the firm is representing the buyer. So same kind of process. real estate broker and his affiliates may act for more than one party in a true transaction as designated agents only with informed written consent. With the consent, a real estate broker may appoint one or more licensees to act as a designated agent on behalf of the purchaser and may appoint one or more other licensees to act as a designated agent on behalf of the seller for a potential real estate transaction. Now, the disclosure form, the mandatory licensee, real estate licensee, consumer, what am I missing? Licensee, consumer relationship disclosure form is just that, a disclosure form. It doesn't obtain consent. So you do need to get the consent separately, either as part of the listing agreement, part of the buyer agency agreement, or in a standalone form separately. Appointment of a designated agent shall not be made unless the party has consented at the commencement of the party's relationship with the real estate broker that the party's designated agency relationship shall not extend to any other licensee affiliated with the broker and shall be limited to the licensees appointed as designated agents. So you're going to appoint one or two or three, you know, depending if they're a team or individuals, to represent the seller and another one to represent the buyer, and you have to get their consent up front in order to do that. And you have to notify them as part of the disclosure, that's the contents, that nobody else in the firm represents their interests. So that's important. If you don't go through that process, then you go to the default position where everybody in the firm is deemed to be a seller's agent and everybody in the firm is deemed to be a buyer's agent. So the importance of that is that, you know, in order to practice designated agency and only have Leaf representing the seller and Bill representing the buyer, you have to go through these steps. You have to get consent, and then you have to give notice if and when it occurs. Again, the designated agency legislation, upon appointment of a designated agent, the responsibility to satisfy agency duties owed to a purchaser or seller shall be solely the responsibility of the designated agent. Nobody else in the firm has any direct fiduciary duties to either client. It's just the designated agent. When a designated agent is appointed, information known or required by the designated agent shall not be imputed to the appointing broker or salesman or to other affiliated licensees. So whatever information Leaf acquires from the seller about the property is not imputed to anybody else in the firm. It stays with Leaf, and he doesn't have any obligation to disclose that to anybody. Same on the buy side. When a real estate broker has appointed designated agents for both the buyer and the seller, the broker or salesperson shall be presumed to be a dual agent. So I think that's the question you were asking earlier. So as the managing broker, you can't really take sides. You've got two agents, one representing the seller, one representing the buyer. You can't really basically advocate for the seller to the detriment of the buyer. So this is basically saying you're neutralized as well. You know, you can maybe give general advice, but you know, it shouldn't be to the detriment of one to the advantage of the other one. Appointment of a designated agent shall not limit the liability or responsibility of the appointing broker or salesperson for breach of duty by a designated agency. So the firm and the managing broker is not off the hook just by doing this. You're still exposed to whatever claims there might be, you know, for breach of fiduciary duty, misrepresentation, et cetera, et cetera. So they're just clarifying that. There's no change in that. And this is the important point about the form. So if you use the consent form that contains the necessary elements that MAR and GREB make available, it creates a conclusive presumption that the purchaser or seller has consented to designated agency relationship if he assigned the form, and it contains all of that information. And it needs to be signed no later than the date that the buyer makes or submits an offer to purchase the property or that the purchase and sale agreement is executed, whichever is first. Consent may be given before identifying a property or a transaction. So again, I think from a best practices standpoint, it's important to do it up front so it doesn't come as a surprise if and when it occurs. Nothing herein shall require written notice to each prospective purchaser or seller who attends an open house showing of real property, provided the broker salesman must conspicuously disclose the agent relationship. So you can have a tent card at an open house basically saying that you're acting as a seller's agent, and that suffices. You don't have to give an agency disclosure to every person that walks in. If you start working with them afterwards, then you should follow up with an agency disclosure. Sub-agency, we talked a little bit about that before. That used to be the only game in town. Well, the agency the legislation basically did away with that, because this is what you would have to do to practice subagency. You would have to, no real estate broker or salesman shall enter into or offer subagency agreement to another real estate broker or salesperson when marketing a property for sale without informing the seller about the vicarious liability and obtaining the written consent of the seller. So that's why that's basically gone by the boards, because I'd have to tell Bill that, by the way, Leaf works for another firm, and he wants to be your sub-agent, but you can be liable for anything that Leaf does or says, and you have to consent to that before it happens. Are you okay with that? I would say probably no. I mean, most sellers would, and so that's basically eliminated sub-agency entirely.
And your MLS still has that.
Right, but does it ever get used? I seriously doubt it.
I've seen it once or twice.
Yeah, maybe the old timers, I don't know. But facilitator, a real estate broker, or salesman may provide services as a facilitator who does not represent a buyer or seller and who does not act in an agency capacity. So facilitator is the third option. You can be a seller's agent, buyer's agent, and designated seller's agent or buyer's agent, or a facilitator in a non-agent capacity, and we'll get into that further in a minute. So those are the statutes, that the laws that the legislature enacted. Then the legislature also gives authority to the regulatory agency, in our case, the Board of Registration, Division of Professional Licensure, to promulgate regulations that further define and clarify the laws and add a little more flesh to the bone. They can't do anything that's inconsistent with the laws, but they can further, clarify some of the requirements. So we'll get into the regs now. This is the Massachusetts Agency Disclosure. Now, I just noticed that they really needed to change the title on this, because agency disclosure for real estate agents representing the seller or buyer. Well, with facilitator as a choice, they really should change that language, because it's not just if you're representing one or the other. A real estate broker or salesperson shall provide to respective purchaser of real estate a notice developed by or approved by the board which clearly discloses the relationship of the broker or salesperson to the prospective purchaser of real estate. The notice developed by the board shall be provided to a prospective purchaser or seller at the time of the first personal meeting between the prospective purchaser or seller and the broker or salesperson for the purpose of discussing a specific property. So hold on to that thought, because we'll get back to that in a minute, in one of the scenarios. So these are the choices here. The seller or buyer, on the form, the mandatory agency disclosure form, the seller or buyer receiving this disclosure is hereby advised that the real estate licensee named below is working as a, so there are the three choices: seller's agent, buyer's agent, or facilitator. If seller's agent or buyer's agent is checked above, the real estate licensee must complete the following section. Non-designated agency. The real estate firm or business listed below and all other licensees, affiliated licensees, also working as the agent of the seller or buyer. So, this was kind of a compromise when the legislation went into effect to allow people to continue to work the way they did before. So some firms were saying, well, I'm going to just exclusively be a listing agent, listing broker. I'm only going to represent sellers. Or other firms said, I'm only going to be a buyer agency firm. I'm only going to represent buyers. So this enabled them to basically continue to do that if they wanted to. But unless you're in one of those categories, I really don't see any reason why anybody would practice that way, because everybody in the firm is deemed to be an agent of the seller, every listing seller, and every buyer client. So designated agency, only the licensee named herein represents the seller or buyer, and then the licensee gets named in that. So again, I think that has really simplified the practice and enabled brokers to just designate agents to work for individual buyer and seller clients. This is a little dense, and I'll try to highlight it, but so these are the regulations that kind of add a little flesh to the bone of the laws. Real estate broker salesman shall provide a written consent form. Again, that's consistent with the statute, which shall clearly state that the broker salesperson will be representing both the seller and the prospective purchaser in the purchase of property, of real property. Again, these are the dual agency regulations. Then we get into the designated. The consent form must state, and this is where the legislation basically said that it has to be in a form that's consistent with what the regulations say. So this is what it has to contain. that the dual agent assists the seller and buyer in a transaction, but shall be neutral with regard to any conflicting interests of the seller or buyer. So they're basically neutralized if you're the same agent representing the buyer and the seller in the same transaction. Consequently, the consent form must state that the dual agent will not have the ability to satisfy fully to the duties of loyalty, full disclosure, reasonable care and obedience to lawful instructions, but shall still owe a duty of confidentiality of material information and the duty to account for funds. The consent form must provide that material information received from either client that is confidential may not be disclosed by the dual agent, except, and these are the 4 exceptions to that, if disclosure is expressly authorized. So if the seller authorizes you to disclose to the buyer that I'm being relocated, you know, and I'm anxious to sell the property, you know, then you're authorized to do it. But otherwise, that's not something that you would be able to disclose. If such disclosure is required by law, if you get a subpoena to disclose the information, if such disclosure is intended to prevent illegal conduct, or if such disclosure is necessary to prosecute a claim against the person represented or to defend a claim against the broker or salesperson. So if you get sued by the, you know, by the broker, you know, any information that you have from that relationship you can use in your defense. And lastly, the consent form must state that the duty of confidentiality shall continue after termination of brokerage relationship. And that's in the Code of Ethics as well. Your duty of confidentiality doesn't end when the transaction closes, so you're still under a duty of confidentiality to maintain personal and confidential information even after the relationship ends. Again, consent may be given by a seller in a written agreement to list their property for sale. That's what I was talking about before. By a prospective purchaser in a buyer representation agreement, or in another document. That's the standalone agreement, consent agreement that CREB and MAR have. When consent to dual agency has been given by the seller or prospective person in advance, then written notice must also be given to the broker salesperson after a transaction has been identified, stating that the broker is a dual agent with regard to the transaction. So again, 2-step process: consent and notice. Again, and this is what it would have to contain: that the seller's agent will represent the seller and will owe the seller the duties of, you know, fiduciary duties. All other licensees affiliated with the appointing broker will not represent the seller, nor will they have the other duties specified herein to the seller, and may potentially represent the purchaser. So you're putting them on notice that the other agent, other agents in the firm may actually be representing the other party in a transaction. And if designated agents affiliated with the same broker represent the seller and purchaser in a transaction, the appointing broker shall be a dual agent and neutral as to any conflicting interests, but will continue to owe the seller duties of confidentiality. So that's, again, that's the same question, that the appointing broker, the managing broker, is considered to be a dual agent and basically neutralized when that occurs. And then the same holds true for the buy side. Conclusive presumption that the seller or purchaser has consented if they sign a form that substantially contains that information that I just showed you on the prior slides. Designated sellers, buyer's agent in a transaction are affiliated with the same broker, and the seller and purchaser each have consented. A separate consent to dual agency shall not be required. Yeah, you don't have to get them both to sign the same form. They can sign and consent to designated agency separately. Again, this is reiterating what was in the agency, the statute already, that if it's done in advance, then the written notice has to be given again. So it's a 2-step process: the consent and then the notification. The designated real estate broker or salesperson exclusively represents the seller or purchaser and is responsible for the performance of any duties owed to the seller or purchaser. Designated broker or salesperson may not share known or acquired information with any other real estate agent or person that would harm the seller or purchaser's interest in the real estate transaction, except for known material defects in the real property. The designated broker or salesperson shall have an affirmative obligation to disclose known material defects in the property. So this doesn't alter or change the basic obligation to disclose known defects in the property. If you're representing the seller and you know of defects and the seller says, I don't want you to disclose that, you still have a legal obligation to disclose that information. Appointment by a broker salesperson of another affiliated broker to represent the seller shall not limit the liability or responsibility of the appointing broker. So again, it's just reminding you that, you're not off the hook just because you designate somebody to represent the parties. An appointing broker salesperson who designates, the same thing about the appointing broker is considered to be a dual agent, but there's no additional disclosure that's required in that case. As long as it's in the upfront, in the consent, then that satisfies this requirement. So anybody that's in an agency capacity has fiduciary duties. This is from the NAR website, Fiduciary Duties, and I'm just going to highlight mainly the loyalty one. This duty obligates a real estate broker to act at all times solely in the best interest of his principal to the exclusion of all other interests, including the broker's own self-interest. A corollary of this duty is the duty to avoid steadfastly any conflicts of interest that might compromise or dilute the broker's undivided loyalty to his principal's interest. So it's a pretty high standard, that an agent undertakes, being an agent. Disclosure, obedience, reasonable care, and diligence, and accounting, that all's wrapped up into the duties that agent owes to a client. So these are some questions that I think Leaf passed on to me that came up to talk about. So, can one act as a facilitator with a buyer if one is also the listing agent of a property? What are the duties of a facilitator? How would I work with a consumer as a facilitator? Anybody want to take the first part of that question? Can one act as a facilitator with a buyer if one is also the listing agent of a property?
I would say yes. If they just walk into your open house, you have no knowledge whatsoever of this individual. You have a relationship already with the seller.
Mm-hmm.
I'm not going to jeopardize my relationship with the seller because I have no knowledge. This individual just wants to make an offer at this stage of the game. As long as they have all the required documents,
Mm-hmm.
I would sign them up as a facilitator.
The only problem with that is that, by definition, a facilitator, the wrong one. The only problem with that is a facilitator, by definition, does not represent either the seller or buyer in the transaction. So if you have an agency relationship with the seller, you have an agency relationship with the seller, and you can't be a facilitator for the buyer. Your only option under those circumstances would be to disclose to the buyer that he's to or divided the same with any person who, being required to be licensed as a broker or salesperson in this or any other state, is not so licensed. I don't want to get off on a tangent here, but I raise that because of two reasons. Teams, in some team situations, I think it may not be uncommon for the team leader to be paying the team members or to be paying personal assistants part of the commission, which I think would be problematic under that. So I'm just raising that as an aside, but I don't want to get into that now. Or committed any act expressly prohibited in sections 87 RR to 87 CCC inclusive. And all of the statutes that I referred to before are in that range of statutes. So, and this is just the regulatory penalties. That doesn't speak to the buyer or the seller feeling that you've breached a duty to them, and them filing a personal lawsuit or a claim or 93A to start with against you. Agency scenarios. So came up with a few agency scenarios, some that are not so hypothetical, because I've seen them. Buyer's agent takes buyer-client to see a property. Buyer-client falls in love with the property and wants to submit an offer on the property. Only problem is that the buyer is not the only one who fell in love with the property. The buyer's agent also fell in love with the property and also wants to submit an offer on the property. She tells you that she wants to terminate the buyer-agency relation and submit an offer on her own behalf. What's your advice?
When you did your buyer agency contract, it specifically says in there that you or people within your firm, in my traditional agency, might also have buyers that could make an offer to on that property, and you can't favor one over the other, right? So you're all set.
Well, I think she needs to be prepared for defending a regulatory complaint for breach of fiduciary duty. Because it's,
Does anyone want to say
that's,
that? You're the one telling them to say that stuff.
isn't it?
I know, he's over here.
Because that's totally inconsistent with your duties to the buyer-client. And as we were saying before, I don't think you can just terminate your client relationship and say, you know what, just forget about that. And now I'm going to do something exactly contrary to your interests. So our advice in those circumstances, and I'm glad the agent heeded that advice, was don't touch that property. That's your client. Remember the fiduciary duties? You're putting the principal's duty, best interests above yours. Well, this would be exactly the opposite of that. So,
But Bob, just hire that you work.
yeah, a different buyer. Right.
No, I'm saying like, just, because one of the things that I think is so useful about that buyer agency contract is when it says, because like in small towns that a
Yeah.
lot of us work in.
Yes.
You could have more than one buyer. on the
Exactly.
same property.
Yes, and that's if a
So
buyer
let's just
agency.
get that out in writing.
No, I agree. I think that's if a buyer agency agreement is used, buyer representation agreement, which I think is the exception rather than the rule in most cases. But yes, I think that's important to specify in the buyer representation agreement that it's possible that you may represent other buyers that may be interested in the same properties, and as a notification to them that could occur.
Can someone other than yourself represent you as the buyer of that same property?
I don't think that gets you out of that problem because you're still, you're still the one that's.
Unless I want the property, I'm gonna buy it.
Yeah.
Right.
I will treat each party equally, but I can't insert myself into the middle of that.
Okay, this has been an ongoing problem for I don't know how long. This one, Agent A goes on a listing presentation and gives the seller an agency disclosure indicating he's acting as a seller's agent. Remember, first personal meeting to discuss a specific property. So he's dutifully giving the agency disclosure indicating he's a seller's agent. Agent A does not get the listing and seller lists with Agent B. Agent A now has a buyer client who is interested in the seller's property. Is Agent A a dual agent under those circumstances? He's given an agency disclosure saying, I'm working as a seller's agent. Now he has a buyer client. What's the deal with that?
They would be, yes.
All right, Bill.
There's an inherent problem with the form.
Right.
The form
Right.
is designed to do two different things. It's designed to say, if you hire me, this is what I'll be. And then after you're hired,
Yes.
it says, this is what I am.
Yeah.
So it inherently
Yeah.
causes two different problems.
Yeah.
Now, I would not go so far as to say you have effectively established an agency relationship
Right.
unless they agree to
Exactly.
that during the.
I do too, but it's still presenting this conflict
Yeah.
because it's a
Yeah.
first personal meeting to discuss a specific property, and who are you at that point in time? You might want to be a facilitator.
Right, that's how I always sign a facilitator.
I think that's
because you don't
that's
have a
certainly
contract
one.
with
Right,
me.
right.
So you specifically
Exactly.
tell me I'm gonna represent, then we switch it up and now
Exactly,
I'm a seller
exactly.
agent.
I think
So am
that's
I doing
I
that
think
right?
that's a good
Okay.
practice. Yeah,
You just
I do.
made me panic.
Bill, you good with that?
I think that's a better procedure, because if you do it the other way,
Yeah.
you may become the test case.
Right, right. So I think that's the best practice.
Can I just make a comment
Yes.
on that specific subject? I happen to be at two different listing appointments in the last 6 weeks. I was the third agent in both of them. And when I pulled out the disclosure form, the potential clients hadn't seen them with either of the other two agents.
I hear that. I hear that.
So it's happening.
I hear that all the time too.
I get
That's what
the
I'm.
opposite, they'll say to me, well, how come you didn't check off seller? I'm like, 'cause I'm not representing you as a seller's agent.
But I'm saying they didn't do them.
Overall, yeah. Let me just close this loop on
Yep.
it very quickly. So they check facilitator, you leave, you come back the next day to have them, you hire you and do your list of contract, have them sign another form.
Yes,
that
yes,
checks all of it.
yes,
No, that's
exactly,
not
yes.
just stating.
You know, I know that they didn't show it at all.
Okay, let me throw this one at you. Your sales associate goes on a listing presentation and shows the seller a CMA that supports a sale price of $500. The seller says they're not in a hurry to sell and want to test the waters at $550. Your associate gets the listing and puts the property on the market for $550. The same sales associate now has a buyer client who's interested in the same property and wants your sales associate to prepare a CMA. what do you tell a sales associate? So if you give them the existing one, that's going to undermine the seller's position, and the seller's not going to be too happy about that. And how do you do another CMA that's going to show a $550 price if you've already done $500? Anybody want to tackle that one?
Hell no.
Nobody wants to.
Yeah.
Well,
Exactly.
yes, I'm sorry, yes, this is dual agency. But you're now in this conflict of interest where, you've got information, you've done a CMA for one, and the other one wants you to do a CMA. So the way we tackle this is we have language in our listing agreement and buyer agency agreement that if a dual agency situation has arisen and we have already prepared a CMA, that we can't give it to the other party unless we have the consent of the other one, and we get them to agree to that in advance. But what are you otherwise do under these circumstances? And if you tell a buyer, you should go in at $550. I mean, that seems to be a direct conflict. If you know that the comps only show $500. So anyway,
in the listing agreement, there's language
That-
that says
we-
if you're a dual agent,
yes.
we
As part of the consent that we have in the listing agreement, we've added language that addresses this. We don't use, we have our own Coldwell Banker listing agreement that we use for that.
Neither Grub or Lar have
Right.
that detail,
Right.
level of detail in their homes.
so we recommend that we add it.
You want to take the fifth?
I don't know, I'd have to think it through a little further.
Liz,
So
who's
what
works
would you
on
do in that situation?
Okay, we already talked about this one, listing agent.
I'm sorry.
Wait,
Sorry.
we're still
Can I
checking.
Yeah.
just ask Bill's opinion if he,
Yeah.
just because if he has to think about whether or
Yeah.
not he would put that, I
Oh.
want to ask him.
Yeah.
Well, in a market where we're competing now because there's a shortage of inventory in that, yeah, we would want to know. How do you answer that?
That was my ventriloquist.
Go ahead, yeah, there you go. I know Bill.
I think Bob is right that I did a CMA when I was just representing the seller that said I think it's $500. Now I'm going to dual agency, I can no longer advise, advocate, or negotiate. So I can't give that same one that says, I think it's $500, and yet I put it on the market for $550 because the sellers wanted it for $550. Because you're undermining the sellers,
So
and
you
giving
just-
out, confidential information that you weren't at the time you were not in dual agency to the seller. And now you've gone into dual agency, so your role has now changed. So I would agree that you could not do it for the buyer, give them a CMA. And I'd go on to say, while Bob is forward thinking and has in the contract, this is how we handle it.
Yeah.
No seller is gonna say, yeah, give them the one that says it's worth $500.
Right,
My
of course.
property is
Right.
marked for $550.
Exactly,
So
exactly,
it-
exactly.
It wouldn't happen anyway in
Yeah.
either scenario, so
Yeah.
So then you just say to the buyer, hey, I'm in a dual agency.
Yes, exactly.
Neutrality.
And I'm neutralized, and I can't, yes, and I can't advocate for either party. Yes.
And-
Wait a
and
minute,
in
you cannot
reverse-
provide them any data?
Yes, you
I
can.
disagree, I think you
Of course
can,
you
you can't
can.
say these are competing properties, but you can provide them a list of properties that sold.
That it's sold?
Right, you just
And
can't,
they can
Yeah.
come to
you
their
can't
own
coach and
conclusion.
interpret.
Yeah.
So
Yeah.
advise, advocate, negotiate. Right, I can't say, this is my opinion on this.
Right.
I can just say, here are all the properties
Yeah,
in the market.
yeah, I think I would stop at that.
Exactly.
That
Okay.
is
For that
sold
period.
within the past 60 days or
Exact
whatever
period.
timeframe.
Here are every property that's sold in the last 60 days in the town of Auburn. Everyone, with no pricing at all.
Okay, I got a few more to run through. Liz, who works as one of your agents, is the listing agent on 123 Main Street. A buyer contacts Liz directly but doesn't want to work with Liz as a seller's agent or dual agent. Liz tells you topic of agency. I've been with Coldwell Banker for 16 years as Vice President and General Counsel. Before that, I was General Counsel to the DeWolf Companies. Before that, I was in private practice for about 5 years, did about 1,000 closings. Before that, I was General Counsel to a mortgage company. So I've kind of been in the business for a while. There's a lot I want to cover here, and to give you an idea, first technical problem. Can you solve it, Brad?
It takes a 60-year-old's hand.
It was working before.
I know.
Yeah.
Yes, eat, please. So good. It's really
Oops.
good. I love it. Where did you get that thing?
Get rid of. Oh boy. It doesn't seem to be working from there. If you hit end shelf, will that stop?
Sounds like a good chance to go.
Okay, here we go. All right. Is that working? Yeah, great. All right, terrific. Thanks so much. Sorry about that. No, no problem. Sorry about that. So here are the few things that I want to cover. Definitions of agency and fiduciary duty, where we have been, agency practice in 1980, 1983 Federal Trade Commission study, how we got here, agency practice from 85 to 2005, where we are now, 2005 agency legislation and regulations. And I need to do a disclaimer here that do a boring alert, because we are going to talk about agency laws and regulations, and it can be a little boring, but if you have questions about agency, the best place to go for answers is laws and regulations. So we'll try to go through those. I'll try to highlight the provisions that I think are most relevant. Fiduciary duties, more specific details, agency discussion questions, agency scenarios, and then some areas that you probably don't typically think as areas of exposure, but because of the agency relationship, there are some other areas such as wire fraud, email and text communications, general liability claims, insurance subrogation claims, and copyright infringement claims. So I'll touch on those if we have time to get to those. So just to start with, agency, this is a Black's Law Dictionary definition of agency: a fiduciary relationship created by express or implied contract or by law whereby one party, the agent, may act on behalf of another party, the principal, and bind that other party by words or actions. That's a little scary. We'll talk a little more about that later on. It's a consensual relationship between two people, and to the extent that one is authorizing the other one, they can act on behalf of the other person. So a lot depends on how much authority is given to that person. Fiduciary duty, a duty to act for someone else's benefit while subordinating one's personal interest to that of the other person. It is the highest standard of duty implied by law. So you really have to work in the best interest of your client is really what it comes down to. And I just put this up there to begin with because I think it's important to keep this in mind, because I don't think a lot of people really pay enough attention to the agency relationship. And it is important to keep in mind as part of your practice, because when you work with clients, you're in an agency relationship. So taking a step backwards into 1980, no agency disclosures were required. Only game in town for listing agents was to be a seller's agent as a listing seller client. For cooperating brokers, the only game in town was to be a seller sub-agent. There was no buyer agency. So even if you were working, helping your son or daughter to buy a property, the only way you could get paid would be if you were a sub-agent of the seller. To take it a step further, even if you were buying for yourself, the only way to get paid would be to be a sub-agent for the seller, which is a totally irreconcilable conflict of interest. But nevertheless, that was the way things were back in those days. And the way they came up with it said, well, it's not really, there's really a problem with that, but we'll just have disclosures to take care of that. So they have they came up with a conflict of interest disclosure that basically said that if you're buying or acquire any interest or represent a client in the buying a property in which the broker or salesperson or his or her kin has a personal financial interest, the broker shall fully disclose that in writing to the parties. So I would just have to disclose that I'm buying for myself, and then I would still be a seller sub-agent, but I would be informing you that I'm acting as a sub-agent, but I'm buying for myself. And how crazy that sounds today in terms of where we are today, but that's the way things used to be. Anyway, there were a lot of complaints that grew out of this. And there were a lot of complaints to the Federal Trade Commission, and they basically said, there's something wrong with this picture. So they did a study back in 1983, and they found 57% of the buyers surveyed indicated that they thought that the agent who handled the purchase of their house was representing them. So either the buyer misunderstood what was going on, or the seller or the agent, misunderstood what their role was. But again, no disclosures at this point, so people are, confused about what roles people are playing. 71% of buyers who dealt with a cooperating broker, as opposed to those buyers who dealt with the listing broker, felt that the agent who handled the purchase of the home was representing them. And 30% of buyers dealing directly with the listing broker felt that the agent was representing them. 73% of buyers reportedly told the agent with whom they worked the highest price they would pay for the property. Again, as a sub-agent, which is the only game in town, you now have this information which you are duty-bound as an agent for the seller to disclose to the seller. Meanwhile, the buyer thinks that you're representing them and you're working in their best interest. 83% of buyers surveyed felt that the information that they had given to the broker regarding how high price they would pay would remain confidential. 66% of sellers surveyed indicated their broker told them how high they thought the buyer would go. A lot of confusion, a lot of misunderstanding about roles people were playing at that time. Then this is their conclusion. There is some indication that this reliance on brokers is related to a lack of disclosure in their role. Another aspect of underrepresentation involves the broker's potential failure to show and promote equally all homes which may be appropriate to the buyer. So if I had a listing and there was another property that was more suitable for the buyer, that was $10,000 less, and they were equivalent, I had no obligation to basically inform the buyer about that, and I could steer them right to my listing without breaching any fiduciary duty, because I was only representing the seller, even though I was working with the buyer. 89% of buyers surveyed expected their broker to inform them about all homes that would probably be suitable for them. No obligation to do that. In fact, contrary to that, they were obligated to work in the best interest of the seller. If representation of buyers is a legal possibility, why do so few brokers provide such advice or such service? One possible answer to this question might be that the industry, educational, and training programs may influence brokers to believe that buyer representation is improper when they're acting as cooperating brokers. Not so much, it's more the compensation that was the factor at that time, because people, the only way they could get paid is if they accepted the offer of compensation in the MLS for sub-agents. So again, it was the only game in town. The agent who uses the MLS may be considered to have effectively appointed all of the members of the MLS as his or her other sub-agents on a blanket basis. That's just the way it worked in those days. Bill, you agree?
100%.
Okay. Sellers believe that where a cooperating broker is involved, whether in a different firm or in the same firm, that broker represents the buyer. So the sellers were under a misimpression as well about the way this system was supposed to work. In fact, most sellers might be rather surprised to know that under the law of agencies, they may be vicariously liable for the misrepresentations of a cooperating brokerage if such brokers are in fact their sub-agents. If a cooperating broker were clearly the buyer's agent, the seller would be relieved of such exposure. Seller sub-agency. If I'm acting as a sub-agent and I say something that the buyer relies on, that is directly attributable to the seller, just as a listing agent if they make a misrepresentation. So as a listing agent or as a seller, you didn't even know what the other broker, who was the cooperating broker, was saying to the buyers that you could be liable for. So in any event, that was the landscape back in 1983. So the state started taking notice of this, and they started, well, at least we need to have disclosure laws about what capacity you're representing, or what your relationship with a particular buyer or seller. So again, I'm saying arrival of, but not ongoing resistance to buyer agency, because there was still this tension between the compensation and the representation. Early on, you would see 0 offers of compensation to buyer's agent, or 1% offered of compensation to buyer's agent, which had an effect of discouraging people from representing buyers and acting as buyer's agents. So it took a long time to get acceptance. And then meanwhile, at this point in time, there was a lot of confusion in the marketplace, and these different theories came out about, well, if one of your agents is operating as a seller's agent, as a listing agent, then all agents in your firm are deemed to be seller's agent. And if another buyer in your firm is representing a buyer, then every every agent in your firm is deemed to be a buyer's agent. And it went so far as to basically say, if one of your agents has come to show the property as a sub-agent, and another agent has come to show the property as a buyer's agent, then everybody in your firm is in dual agency. And unless the seller accepts and consents to dual agency, you can't even show the property anymore. I mean, it got that crazy. In any event, this went on for quite some time. And then Mar kind of took the initiative here. And Bill Mullen was kind enough to actually chair the first task force to try to come up with some recommendations for agency law and regulation. And Bill, I don't know if you want to chime in, but that was a valiant effort on your part. You are acting as a seller's agent. You can't be a facilitator, which implies that there's no agency relationship. So you couldn't be, in that scenario.
But a facilitator has no agency relationship.
Right, with either party, but you have a relationship, you have an agency relationship with the seller. So that is the overriding relationship that you have in that situation. You can only be a seller's agent to both to both the buyer and the seller. You can't be a facilitator, which implies that there's no agency relationship. A facilitator owes the seller and buyer a duty to present all property honestly and accurately by disclosing known material defects and to account for funds. Unless otherwise agreed, the facilitator has no duty to keep information received from a seller or buyer confidential. Should the seller or buyer expressly agree, facilitator relationship can be changed to a seller or buyer client relationship with the written consent of the person so represented. So 2 important points here. The second one, there's no duty of confidentiality. So, and that's described in the agency disclosure form, the consumer licensee relationship disclosure form, that a facilitator does not have an obligation to keep it confidential. You can agree to that, if you want to keep information confidential, but there is no underlying obligation to keep it confidential. The information that you obtain from either party. Yes.
To go back on your scenario there, my understanding is you can't be two of anything, right? You can't be one thing to a buyer and one thing to a seller.
Well, you could be.
Unless you're a dual. But
Yes,
both
unless you're a
parties
dual.
are
Exactly.
acknowledging dual.
Exactly.
You're
But
still one- that's
if you're a
the
seller's
one.
agent, right? The only option unless the buyer agrees to be represented and both of them agree to dual agency, your only option, when somebody comes in.
But you still only have one title, either under dual. So I'm just trying to
Yes.
simplify it, right? And I'm asking.
Yes.
This is how I understand it. You can only have one label in the transaction, right? As the realtor, you're either going to be a seller's agent,
Yes.
a buyer's agent, or a dual agent.
Yes, I think that's accurate.
Okay.
Yes.
And I thought
Oops.
each one of those was attached to a side. So you're either buyer because you're representing the buyer, seller because you're representing the seller, or if someone comes in as a facilitator with a buyer, they're not really a facilitator for the seller either, are they?
No. In that case, they're just they're neutral. They have no relationship with the seller under those circumstances. Do you know what I mean?
Essentially, they have no relationship with the buyer, right?
Right. Well,
You're saying
it would just be a
confidentiality,
facilitation.
But that's their label in the transaction.
Bill.
So let me close that loop. You can still write the offer, and the buyer is your customer.
Yes.
So your label still is listing agent, and you represent the listing agent, but you can write the offer in your customer. I think where the confusion comes from is we look at facilitators working with customers also, but you can't use the label facilitator because by definition, it says you don't represent either the buyer or the seller, and you are representing the seller.
Right.
So in your example, you can write the offer, seller is M represented, and your title would be listing agent, not facilitator, just listing agent.
So the agency disclosure we present to that buyer that comes in is that we are a seller agent.
Correct,
Yes,
and you're
yes.
working with the buyer,
Yes.
checking the box.
Yes. Correct. And one other important point here. Should the seller and or buyer expressly agree, a facilitator relationship can be changed to a seller or buyer-client relationship with the written agreement of the person so represented. So that can happen, for instance, if somebody is filling in for the listing agent in an open house and they don't want to be deemed to be a seller's agent, because then if a buyer comes in and want to be represented, now what are you, a dual agent? And you don't want to be that. So, we recommend that if that situation occurs, that the person that is filling in for the listing broker represent themselves as a facilitator, and then if the buyer does want representation, then you can upgrade to a buyer agent without creating that potential conflict and being deemed to be a dual agent.
What if you're in a non-designated agency?
I'm sorry?
If you're in a non-designated agency?
If you're a non-designated agent?
All the agents
That's right.
represent
That's
the
right.
seller.
That's right. Yes, and all agents in the firm represent the buyer as well. So if you've got buyer and seller being represented by two agents in that firm, they're both dual agents under those circumstances.
But if you're going back to that, if you're the broker doing open house, one of your agents represents the seller.
Yes. Yes. Yep. Okay.
Bob?
Yes.
I don't want to take you off track, but you raised open houses. Can I make a quick?
Yeah, go ahead.
And you might want to take a break because I'm actually going to ask you a question. We've been getting a lot of phone calls recently. I'm sorry, I cover the brokerage council line for Greg, and I've been getting a lot of companies. There's a bigger company out there that does tent cards that say they're a buyer agent, and I'm confused on how they could be a buyer agent because the buyer has to elect
Exactly.
that you work
Exactly.
with them as a buyer
Right,
agent.
right.
And the tent card gets you out of doing the mandatory disclosure and is talking about your relationship with the seller.
Right,
So Bob's
right.
100% correct. I'm a facilitator and I don't represent the seller. We're in a designated agency company. If a buyer walks in and says, hey, I want representation, you can upgrade to representation as the buyer's agent. But I don't know how you can say,
Yeah, I
I'm a
don't-
buyer's agent at an open house.
I
Would you?
agree. I agree.
Okay, I want to make sure
yeah.
we're on the same
I-
page, because I
I
had 3
agree.
calls in the last week
Yeah.
on that issue.
I don't see how you can either.
Okay.
Unless
All right.
the buyer
There's a bigger
consents.
company that's
Unless the
doing
buyer
it.
consents right off the
Yeah.
bat. But what open house has a buyer's agent, hosting the open house? So, I mean,
So is that what they're doing? They're actually
They're-
at an open house
Yeah.
and putting up
A tent card
Buyer
saying,
agent.
I'm a buyer's agent.
second question, what are the duties of a disclosed dual agent? What can and can't I do when I'm acting in the capacity of a dual agent? Anybody want to take that question?
Sure.
Yeah.
What's the question?
All right, what are the duties of a disclosed dual agent, and what can I and can't do when I'm acting as a dual agent?
So you're representing both parties,
Right.
not to the detriment of one another.
Right,
Your duty is to be, fair and honest. You cannot give them any, like we just said,
Yep.
anything that would hurt the other person.
Yep.
You can still provide them with public record comps. You just can't interpret and coach the information. What else?
hold that thought about the comps, but yes, I agree with everything else that you said. A dual agent shall be neutral with regard to any conflicting interests of the seller or buyer. Consequently, a dual agent cannot satisfy fully the duties of loyalty, full disclosure, obedience to lawful instructions, which is required by a seller or buyer agent. A dual agent does, however, still owe a duty of confidentiality of material information and accounting funds. So you're kind of neutralized, basically. You can't advocate for the buyer or the seller. Okay, let me
Do
see.
you have to request the comps before you provide them?
Well, yeah, that's going to be one of the questions that I want to hear what people have to say about that. What are the proper steps for the disclosing designated agency as well as disclosing dual agency? I think we beat that to death pretty much with consent and notification. When and why does the consumer need to have agency explained before any real estate talk is commenced? I think we beat that to death too with the FTC study and why there's a lot of confusion out there. Which is why I think there's a lot of people here today too, because there's still a lot of confusion out there. When can I or can't I change my relationship with a client relative to agency? Once you once you create an agency relationship, I don't think you can downgrade from that. I don't think you can basically say, well, I want to be a facilitator now. I mean, to avoid a dual agency situation, because you already have that client relationship with people, so you can't downgrade. I think you can upgrade, but you can't downgrade. Bill, you?
I would agree. The law doesn't actually say you cannot downgrade. However, Bob's advice and how I always say it is, the problem is, if you're a buyer agent, we'll say, and you get confidential information, and then you downgrade to a facilitator without having the duty to keep confidential, and the buyer then says to you, oh yeah, remember I told you X, Y, or Z?
Yeah.
Now you have, that's no longer confidential. So it puts you in a very increased liability position.
Right.
If you downgrade. And again, I always say you can't do it either.
Yeah, yeah.
And it doesn't specifically, because I don't know about you guys, but at GBOP, they say to me, where can I find that in the law to make sure you're correct? And I can't say.
Well, I think it's in the nature of the agency relationship.
Exactly.
You know, I mean, you've pledged all these
Absolutely.
fiduciary duties to somebody and said, you know what, forget about those fiduciary duties. I'm just going to be a facilitator. Now, I don't think you can do that.
Right.
You know.
Right.
So,
Without major liability.
yeah, I think it's inherent in
Yeah.
the
Yeah.
agency relationship.
I'd agree.
Then the last question was, what are the financial and legal results of me not disclosing or forgetting to disclose or disclosing after consumer has made a transaction decision?
There are none.
No?
No, this isn't your question yet.
Well, I turn to the regulatory penalties section. The board may suspend, revoke, or refuse to renew any license when the board has found as a fact that the licensee in performing or attempting to perform any act authorized by his license has knowingly made any substantial misrepresentation. You know, if I've represented that I'm representing you, and then I actually do something contrary to that, you know, that would be a substantial misrepresentation. Acted for more than one party in a transaction without the knowledge and consent of all parties. That goes back to the consent requirement. Paid commission. Oh, I just threw this in there. Paid commissions or